Thank you. Mr. Chan.
Thank you, Chief Justice and Justices. The Criminal Lawyers Association is concerned with both the issues of standing and remedy. With respect to standing, I echo much of what my friend Mr. Toussaint said. I wish to add an additional case for your consideration, and that's the case of wholesale travel, in which corporations, of course, were allowed to assert the Section 7 rights of individuals in challenge to an unconstitutional law under which they were charged, even though there can never be any connection between the accused corporations and the Section 7 rights asserted, because corporations cannot enjoy the right to life, liberty, and security of the person. And I simply say that if a corporation can assert the constitutional rights of individuals, then surely a supplier of medical marijuana who operates entirely outside the regulatory scheme can assert the Section 7 rights of a supplier who may have at least 1 foot inside the scheme. The only connection required under Big M Drug Mart is that the accused be charged under the impugned law. And this principle, in our respectful submission, should be reaffirmed and not narrowed in any way, particularly given the trend in this court to broaden the rules of standing, as we've seen most recently in downtown East Side. Second point I wish to make to standing, and this goes to the question, Justice Cromwell, you asked, as to whether my friend from the Crown's complaint is really more about remedy. And we say that it is. An accused has standing to challenge the constitutionality of a law under which he's charged, because if he can obtain a declaration of invalidity, then that would operate as a complete defense to the charge. It would remove the basis for the prosecution. Now, just because an accused may not ultimately succeed in obtaining his desired remedy, for example, if the court ultimately decides to read the legislation down in a way that still sustains its applicability to the accused, doesn't mean that the accused should never have been granted standing in the first place. In our submission, to allow speculation as to what the ultimate remedy might be, to dictate the terms of standing, would be to put the cart before the horse. And this exact point was dealt with by Chief Justice Lemaire in his concurring opinion in the case of Ontario and Canadian Pacific Limited, 1995, in which Chief Justice Lemaire said, the fact that an accused is standing to challenge a law does not inevitably mean that he or she will benefit from a finding that the law is unconstitutional. Standing just gets your foot in the door so that you can make your arguments. It does not guarantee success. But that door should not be closed simply because you're not guaranteed success. Dealing then with the issue of remedy. The CLA's position is that this court should recognize that there is a fundamental conflict between the suspended declaration of invalidity when it is used in this context, when we are dealing with an unconstitutional, an arguably unconstitutional criminal offense. There's a conflict between the suspended declaration here and the principle in Big M Drug Mart that no one shall be convicted under an unconstitutional law. And that conflict arises because when we grant a suspended declaration, this court is leaving on the books for a period of time an unconstitutional offense that can be used to arrest, to imprison in pretrial custody, and potentially convict people despite its unconstitutionality. And because of this conflict, we urge this court to insist that the government justify a suspended declaration and show that there's a compelling reason to override the principle of Big M Drug Mart if it's to be used in this context. The Schachter criteria in our submission provide useful guidance as to when it may be appropriate to temper this constitutional principle with practical necessity. If there's a rule of law problem, if there's a public safety problem, or if you're dealing with an under-inclusive benefits regime and you don't want to strip away those benefits from all those who would otherwise be entitled to it. My friend from the Crown tried to place this case within the rule of law category in terms of justifying why a suspended declaration would be appropriate, and argued that because there's a gap in the law that poses a rule of law problem. And I simply say the two are distinct. A gap in the law does not necessarily create a rule of law problem. Otherwise, you would always be suspending declarations of invalidity. It is a bigger rule of law problem to leave on the books an unconstitutional offense that can result in the arrest, incarceration, and potential conviction of individuals.
Thank you.
Subject to questions. Those are my submissions.
Very good. Mr. Loken.
Thank you, Chief Justice and Justices of the Court. On behalf of the CCLA, I will address three brief points arising from the Section 7 analysis. First, the liberty interest is engaged by the threat of imprisonment, and this is enough on the Court's principles and case law to shift the analysis to the principles of fundamental justice stage. There does not need to be a further showing that patients' liberty or security of the person interests are engaged by interference with fundamental personal health choices, although that appears to have been made out on the findings of the case. The second point is, to the extent it's necessary to show that marijuana products are a reasonable treatment choice, the evidentiary bar should not be set too high because of access to justice concerns. That is to say, the requirement for medical or scientific proof may be unrealistic and contrary to access to justice. Thirdly and finally, we say the courts below did not alter the burden of proof when it comes to arbitrariness. At most, there was a shifting of the evidentiary burden as the case unfolded. So on the first point, we say that the liberty interest is engaged by the statutory scheme because both patients and providers may be imprisoned for supplying and possessing cannabis products other than dried marijuana. That has always been enough to pass the threshold stage of Section 7 and move on to principles of fundamental justice. You've seen that in Malmo-Levine and in the PHS case. That's very clear on the law. My friend for the Crown says, well, all that gets you is a review of whether you had a fair trial. It doesn't get you into any other kind of review. I say there's no authority for that proposition, and that's wrong in principle. And if I can just give a little hypothetical example. If there was a law in the books which made it illegal to have a last name beginning with L, so that's a completely arbitrary law, it would be no answer if the government says, okay, you can be imprisoned for that, but you got a fair trial. They produced your birth certificate. It's been proven, and you had a chance to make your case. You would still be entitled on that purely arbitrary law, because of the threat of imprisonment, to take the courts to say it's completely arbitrary. There would be an arbitrariness review. Now, in this case, we have, as in several other cases of this court, we have the liberty interest engaged from threat of imprisonment, as well as the patient choice of medical treatment. Both elements are there, and both are in the analysis. But we say that either gets you to principles of fundamental justice. Now, on the point about the evidentiary bar not being set so high that medical or scientific proof is the only way of establishing your case, we would say the courts below found that the derivative products were reasonably required through the use of patient testimony and expert evidence on a process of what the Ontario Court of Appeal has described as ordinary fact-finding. Unless those findings of fact are palpable or overriding error, there's no basis to say that that doesn't meet the standards that have been set. And if you were to go on and say, well, wait for, you need to have medical professionals testify or physicians testify, and you need also to have scientific studies, that's going to render illusory the scope of the medical exemptions that has been developed in the case law. That would be an unduly credentialist approach with serious implications for access to justice. On my final point, we disagree that the courts below reversed the onus of proof in the analysis of arbitrariness. The appellant complains that the trial judge and Court of Appeal made some comments about how they would have expected to see some evidence in certain areas, such as the alleged difficulties in estimating quantities of THC and derivative products as opposed to dried marijuana. With respect, that was simply a practical, what judges do in practical circumstances, and it's a shifting of the evidentiary, not the legal burden. What the respondent did was to bring arbitrariness in play with evidence that derivative marijuana products are more effective for some patients and some conditions. That raised the question of why it is that they should be prohibited under the statutory scheme. As a practical matter, the appellant then found itself in a position where it would be advisable to provide some support for the claims that are made about why this is necessary, but that was not a shifting of the legal burden, it was only a shifting of the evidentiary burden. And subject to any questions, those are my submissions. I do want to simply add that the CCLA regards the questions of standing and remedy as very important questions, and we adopt the submissions of the CLA on those points.
Thank you.
Thank you.
Chief Justice, Justices, the British Columbia Civil Liberties Association says that the criminalization of modes of ingestion of medical marijuana is an infringement of the right to liberty that extends beyond the mere threat of incarceration. The threat of incarceration, standing alone, is enough to trigger scrutiny. For consistency with the principles of fundamental justice, we say. Similarly, we adopt the respondent's submissions in respect of the very significant effects on the security of the person, regarding which there were clear findings of fact. But we would say that this case affords an opportunity to bring clarity to a zone of the right to liberty that rarely receives treatment, precisely because cases like Morgentaler, Bedford, Portland Hotel Society, Chiarelli, and Carter tend to deal with life and death situations or very, very serious bodily harm. It's also raised because the Crown asks that the right to life be triggered only where there's a life or death situation and where there's serious bodily harm. In response, the British Columbia Civil Liberties Association says that the right to liberty under Section 7 should afford protection to important choices, the restriction of which detracts from the sphere of personal autonomy, individual dignity, or independence from state interference. The right to liberty should only be restricted in scope where it would debase the administration of justice to hear the issue. In Malmo-Levine, the examples were given by this court. Golfing, for example, lifestyle choices. Here, BCCLA argues that all non-trivial choices, especially of a medical nature, all non-trivial choices should trigger the right to liberty. The reason for that is twofold. Firstly, it's found in the place accorded to the right to life, liberty, and security of the person in the overall architecture of the Constitution. The right to liberty, security of the person, and life are they're all triggers for further scrutiny of laws for accordance with the principles of fundamental justice and for justification. So that's the first aspect. It's not, in my client's respectful submission, appropriate at this first triggering stage to take into account the issue of whether affording too much liberty will make society ungovernable. It's not suitable, in my client's respectful submission, to have concerns at that stage about unbridled liberty. The bridle metaphor, in my respectful submission, is not appropriate to the governance of constitutional affairs, where it ought to be recognized that the state exists for the benefit of the individuals constituting it, rather than the other way around. The second imperative, also a constitutional imperative, is the role of the courts in defining the rule of law, in providing transparent and intelligible rationales for restriction of liberty. If the scope of liberty is defined too narrowly, the court will not have an opportunity to serve its proper constitutional role in providing transparent and intelligible reasons for the restrictions of liberty, and for properly scrutinizing the justifications afforded by the Crown for those limitations. That imperative to provide intelligible justifications is underscored by this Court's comments in the succession reference, that democracy, for its justification, relies on the application of the rule of law. There is no social compact, no real contract that citizens sign when they're born into citizenship. Instead, we are left for surrogates for that constitutional legitimacy, and that legitimacy derives from the justification exercise engaged in by the courts to ensure the primacy of the individual over the state in the form of demanding justification and consistency with the principles of fundamental justice. And that brings my time to an end.
Thank you very much.
Thank you.
Reply.
Chief Justice, Justices, first, with respect to remedy, the statement of constitutional question in this case is very specific. Whether the restriction of the MMARs to dried marijuana is inconsistent with Section 7 of the Charter.
I think we have to remember that the statements of constitutional questions are only intended to provide notice to attorney generals and others, and they are not in any way binding. And it may well be that the real gravamen here has to take into account the law as well. Otherwise, of course, there would be no offense. What we're dealing with is an exception. So I don't want to cut off your argument, but I wouldn't put too much weight on the constitutional questions.
Chief Justice, I think I may not have made made it clear the reason I'm saying that. The specific issue is alleged constitutional infirmity with respect to one component of the regime. That's the restriction to dried marijuana. So Mr. Tousaw refers to the number of producers and the many other aspects of the regulatory scheme, which have drastically changed with the introduction of the new regime, the MMPRs. Totally different scheme. Moves to a model where instead of designated producers, you've got commercially licensed producers treating this substance as closely as possible, that is marijuana, to other drugs that are regulated for pharmaceutical purposes. So my point is that the issue is the restriction to dried marijuana, not all of the other complaints that have been litigated in other cases and have been responded to and are still undergoing litigation. And so if there is a remedy, the Crown says it's right on the merits, but if the Crown isn't right on the merits, if there's a remedy, it's got to be focused on the question of restriction to dried marijuana and not jettisoning an entire government program that has at least 30,000 licensed individuals operating under it. That would be drastic and in favor of a judicially legislated defense that's ill-defined, frankly. I'll just say one more specific point. My friend says that the response to Svetkopolis, which was the limit to the number of producers, was to move from 1 to 2. And if you look at the regulatory impact analysis statement for the new MMPRs, which is in the condensed book at tab 4, I believe, what you'll see, excuse me, this part isn't in the condensed book because I didn't realize it would be it would arise. But if you look at the appellant's authorities, tab 13, that's the complete regulatory impact analysis statement. At page 1725, it shows that the government responded to the Svetkopolis ruling by moving from 1 designated producer to 2, and that the amendment was an interim measure intended to address the court's decision while the program and the MMARs were being reassessed. The ultimate conclusion was the MMPRs, an entirely new regime that it moves to licensed producers. So it's a completely irrelevant issue at this point. With respect to my friend, Mr. Tousaw, says, look, derivative marijuana products are as safe or are safer than many approved pharmaceuticals. My friend can't say that, and there's no finding to that effect. And no one can say that. And the reason no one can say it is because there's been no scientific study over with a statistically significant number participants to show that's the case. Indeed, what the Court of Appeal said was the Crown hasn't produced evidence to show that these products are any less safe or more dangerous. And my point from the very beginning has been that that's a reversal of the burden under Section 7 of the Charter. With respect...
Interrupt you, but can you explain why it is you need a suspension of a declaration of invalidity of a scheme that is no longer in force?
Yes, I think it's this, and it goes to the rule of law question. There's no question there's a new scheme now, which has many different facets, but that new scheme maintains the impugned distinction by saying only authorizes dried marijuana. So I appreciate the court will be saying the restriction in the old regime is invalid. There's no question, though, that in terms of the rule of law, everyone will take guidance from what this court says about that restriction. And it will have to be, obviously, that point would be decided. So with regard to the new regime, since it envelopes and adopts that new provision, even though it's not subject to challenge, the government would have to obviously look at responding to the ruling to make sure that the ruling corresponds or that the regulations correspond with the ruling. I have more points, and I'm not sure if I'll be given the time to make them.
Well, very quickly.
Yes. Thank you. With respect to my friend Mr. Tussall referenced doctor's notes, and I'll just point out of the CBCC patients. The Crown at the trial objected to any testimony from patient witnesses about medical opinions of doctors and said that they could give that evidence, but it would not be permissible for a hearsay purpose. And the trial judge accepted that limitation. And that comes from the record, Part 3, Volume 2, page 77, line 1 to 19, and page 83, line 40 to page 84, line 7. And then...
would you confine your points to things that really matter? I think that we have findings, and whatever that particular evidence is, we'll be looking at it. But.
Right. I guess I would just say this, and I'll leave it at this, Chief Justice, that my friend is saying, well, look, there's support for the CBCC witness opinions that they need to use other kinds of substances other than dried marijuana. Look at this letter from a doctor. That's a hearsay letter, and the Crown made it clear on the record that the witnesses could testify about their dealings with their doctors, but any medical opinions through those witnesses would be hearsay, and the trial judge accepted that limitation.
Thank you.
Thank you.
Court will reserve its decision. We thank all counsel. We're adjourned.